Thank you. Well, good morning, everyone. I'm Mitch Menchaca. I'm the Executive Director of the City of Phoenix Office of Arts and Culture, and thank you for joining us today. Before I introduce our speaker, I want to give a shout out to the whole Office of Arts and Culture staff that helped put this together, with Katie, Barry, Ed, Sarah, Anel, Doug, and everyone involved. So thank you for joining us. This will be the last of the workshops probably for this calendar year, and then we'll ramp up in 2021. So I want to say thank you also to Sarah for being with us for the past few weeks and providing the knowledge for the Artist in the Know series. So I'm happy to introduce Sarah Conley Odenkirk. She's the founder of Art Converge and has practiced law in the area of fine art for more than 25 years. She advises clients in transactional and policy matters related to all aspects of art business in the private and public realms, and provides cultural strategy guidance through a legal lens. Sarah is the author of a surprisingly interesting book about contracts for artists and other creatives, and publisher of an online database and the comprehensive resource guide for public art and private development. She is a frequent speaker at professional conferences in both the legal and art fields, and we're lucky to have her today. So take it away, Sarah.
Thank you. Thanks very much. I'm so glad to be here. And I can't believe this is already our fourth session. So hopefully we can keep the energy going next year. So today we're going to talk about intellectual property and in particular copyright. Intellectual property you may hear referred to as IP. So if I happen to slip into my legal abbreviations and say IP, that's what I'm talking about, is intellectual property. And the reason that we're going to focus on copyright today is that it's generally most appropriately used for the creative arts, music, dance, and visual arts, though I will briefly go through the other types of intellectual property protection so that we can distinguish. Let's see. There we go. All right. So there are three main ways that intellectual property is protected. I'll define briefly and distinguish, and then we'll, like I said, spend the bulk of our time on copyright. So first is patents. I'm sure everyone has heard of patents. Trademarks are the second, and copyrights are the third. There's also trade secret and some other tools that are available, but these are the main three areas. So patents are issued for unique and non-obvious inventions. This is a really important overall definition to keep in mind. Patents really are for inventions. It tends not to be so applicable in the art world, except when, of course, there are inventions made within the art world. A patent is a grant of a property right to the inventor, and it's issued by the Patent and Trademark Office. The term of patents is for 20 years from the date on which the application for the patent was filed, or in special cases, there will be some extension to that. But the website, let's see, first I'm going to get you the definition here up on the screen, unique and non-obvious inventions. And the website is the same as for trademarks, so we'll get to that in one moment. Trademarks are also issued by the Patent and Trademark Office, as I said. A trademark is a word, name, symbol, or device, which is used to indicate goods or services. It will indicate the source of the goods and to distinguish them from goods from others. So thinking of trademarks in terms of being a consumer protection tool is really the best way to clarify trademark from patent, patent being inventions, trademark being a consumer protection tool. And a service mark, you may hear service mark and trademark being used interchangeably. A service mark is basically the same as a trademark, except that it identifies and distinguishes the source of, as you can imagine, services rather than goods. The term trademark and mark are also commonly used to refer to both trademarks and service marks. And this is important just in terms of the lingo. So when you're talking about protecting work, making sure that that it's clear that what we're talking about is, again, like a logo or some distinguishing name, word, symbol, or device. And in some cases, colors or smells have been trademarked. But these are things that are protecting goods and services. All right, so both patents and trademarks are protected through the U.S. Patent and Trademark Office. You can find a lot more information at this website, www.uspto.gov. There are also all the application processes and filing requirements listed there as well. The process for patents and trademarks is fairly complex, and so that's something where you'll definitely want to seek the advice of a lawyer before proceeding with any of that. Copyrights are a little bit easier and user-friendly because they are really designed for creative folks who want to protect their work. So let's get started on copyrights. Let me just point out to begin with that there's something important, especially in the United States, to keep in mind. We have at least 2 layers of law that can affect intellectual property and the related rights thereto. State and federal law both can apply. Copyright is a system that is dictated primarily through federal law. So this is really the only consideration. But once we get into some other rights, like moral rights, which we'll talk about toward the end, there are also state laws that are in place that may apply. This means that where there are both federal and state laws that apply, you can see the differences dramatically sometimes from state to state. But even when looking at federal law, the country is so big, it's divided up into districts, and each district has its own federal court system. And so interpretations and decisions can vary across the country. So when you ask a lawyer a copyright question and you get sort of a "it depends" vague answer, sometimes that's why, because the law is not necessarily settled on all of these points across the country in a very unified way. This is, however, the basis on which lawyers make arguments, right? Using precedents and pushing for one interpretation over another to control when the law is clear. There is a lot that's unclear and undecided. There's a lot of room here for interpretation as well as litigation. And for better or worse, rarely do we have litigation in a lot of the areas that pertain to copyright. There's certainly copyright litigation, but when it comes to the moral rights and sort of some of the more gray areas of copyright law, it's a little bit more difficult to find those legal precedents. So let's see. We're going to talk about 3 different aspects well, I guess 4. We're going to talk about copyright and how you register and protect your work under copyright. We're also going to look at fair use issues, moral rights issues, and then resale royalties briefly. Unfortunately, we only have a half an hour today, but we'll do what we can to get through this. Okay, so the copyright website, separate from the patent and trademark website, copyright.gov. This is an excellent website in terms of the information it provides. There's a lot of material there and explanation for pretty much anything you've ever wanted to know or not know about copyright law. It also has all of the information about filing, registering your copyright, which we will go through briefly here in a moment. The one thing I would say is that the system for actually registering your copyrights is a little bit behind times, shall we say, and so hopefully at some point that will be upgraded, but it is a wizard type system that will walk you through the process, so it is fairly easy to follow. Okay, so U.S. copyright law is derived from the Constitution, and as I said before, it only exists at the federal level. Though we will talk about some of the areas in which state laws apply, it's not with regard to general copyright. So what is covered by copyright? From the very beginning, copyright codified the notion that authors or artists should benefit from the fruits of their labors, and that would be for some specified period of time. The list of what is included has evolved over time, as well as the length of time for which copyrights are protected. So currently, we have a very different law than we had in place when copyrights originally evolved. But the main thing to take away here is that we've got a list here of what kinds of works are covered. And the real important initial concept to understand is that copyright exists in creative works and owned by the author as soon as the work is fixed in a tangible medium. This is a really crucial point, and you'll see why in a moment. But basically, any creative expression that is fixed in a physical or technological format that's viewable or usable by others will be considered to be fixed in a tangible medium. While copyright exists upon the creation and fixation, in order for the copyright owner to protect these rights in court, there has to be a registration in place with the Library of Congress. Registration also entitles the copyright owner to statutory damages rather than just having to prove actual damages. So you may have a violation of your copyright, but it's very unclear how much monetarily you've actually been damaged. If you have the registration in place, there are monetary amounts listed within the law that you're allowed to pursue instead of having to prove the actual damages. This is a huge benefit for those people who have their copyrights registered. Additionally, there's the ability to recover attorney's fees, and there's also a presumption of ownership that puts the registration holder in a much stronger position in the event of litigation. Registration forms, instructions, and a lot of other information, as I mentioned, is available on the website. I think I can pull that up again. There we go. And generally speaking, the registration costs for copyrights is between $45 and $65, depending on the type of registration you're filing. This is much different from patents and trademarks. Trademarks are several $1,000s, and patents can run into the tens of thousands of dollars. So you can see there's quite a difference in the process that you go through and the costs that are incurred for those different types of protections. What is not protected is ideas. And so this is, again, where this concept of being fixed in a tangible medium is very important. Ideas are not protected. That's why you should not talk about your creative ideas at a cocktail party until you've actually fixed something into a tangible medium, whether it's a description that you've written out or actually created a draft of your work and registered that work, protecting it in some way. And let me just back up for one moment. There's a myth that often is repeated about mailing yourself a copy of your work and that being the poor man's copyright or a way to protect your copyright interests without going through the registration process. This is, as I just used the word myth, this is in fact a myth. All it does really is show that you're capable of sending yourself mail. It does not provide any additional protection. So please do consider becoming familiar with the copyright registration process. Okay, so back to this idea that ideas are not protected. Just as an illustration, swimming pools in general cannot be protected. So the concept or the idea of swimming pools is not protectable, but David Hockney's specific rendition of the swimming pool absolutely is protectable. It's the creative elements that he's put into his work that distinguish it from the concept and the fact, of course, that it is fixed in a tangible medium. Okay, so now we know what kinds of works are protected and the importance of registration, but what are in fact copyrights? I find it helpful to think of copyrights as a bundle of sticks, each of which can be separated out, retained, licensed, or transferred separately. So instead of thinking of copyright as one solid thing that attaches to a creative work, really do think about it as something that can be broken up into pieces. And when we do that, we've got a bundle that includes at least the following, and there are several other rights as well, but these are the main things here. First is the right to reproduce the copyrighted work, so to create copies of it. To prepare derivatives, here I have pictured t-shirts as an example of one type of merchandising that might occur in the derivative context. But of course, any works, any additional creative works can also be under the derivative category, would be part of this, this right as well. And we'll get further into this when we talk about fair use. Distributing copies, and here I've got gifts. So the idea being that you give gifts. So distributing copies of the work, performing the work, if you're talking about a piece to be performed, display of the copyrighted work publicly. Often the display right is considered to travel with the ownership of the physical work, but it is in fact one of the copyrights that is protected under copyright law. So let's talk a moment about how this practically applies in the art world. What happens oftentimes here is that people will purchase artworks and they don't really understand that the fact that they've purchased the artwork does not entitle them to the copyright as well. The copyright stays with the artist even once the work has been sold. So unless there's a specific statement signed by the artist that transfers the copyright to whoever has purchased the work or to any other third party, it really is only the physical work that is sold. This is an important point not only for artists to understand, but for anybody who's selling artwork to understand, so that there's a very clear ability to convey that fact about copyright when selling works. When I'm talking with galleries, I often suggest that they put a statement on their invoices to the effect that copyright remains with the artist and you can only obtain that copyright through written transfer of rights. And certainly when I'm talking with artists, I want them to understand that as well, that if they're selling a work, again, whether it's a visual art, a work of visual art or performance work, you're just selling that object, you're selling that performance. You're not selling all of the other rights that go with it unless you specifically write that down as part of your agreement and sign that you're transferring anything else. Otherwise, you maintain quite a lot of rights, and those rights can have value down the road, even if you don't have possession of the physical work. One thing that can be transferred verbally, however, is a license. So you can verbally give permission for someone to use your work. That does not have to be in writing. So how long do copyrights last? They last for the life of the artist plus 70 years. And as I mentioned before, this has not always been the case. This is the case now. It has been since about 1990. So for anything created 1990 forward, you can pretty much assume that that's the case, that it's life of the artist plus 70 years. Prior to 1990, there were several other copyright laws that were in place. And so it is going to depend when the work was created as to which of those laws is going to apply and how long the rights are good for. One thing that comes up even now is works that were created prior to 1990, prior to the 80s, maybe that somebody wants to copyright now as part of a legacy planning effort, as part of an artist's estate. If they were produced earlier and did not have a copyright notice on them, they may not be eligible for copyright protection at this point. They may have fallen into the public domain, which raises another issue, which is that it is very important to put that copyright notice on the works. And I'm not sure I included a slide with the copyright notice, but the proper copyright notice is a circle with the C, the date of creation, and the author of the work or the copyright owner listed there with all rights reserved. Okay, so the reason why this life of the author plus 70 years is particularly important is that, of course, during the term of the copyright, if someone uses the copyrighted material without permission, it's generally considered to be an infringement. Infringement can be remedied with an injunction, which we can talk a little bit more about later if people have questions, which essentially means requiring the infringing behavior to stop, or monetary damages. And as I mentioned earlier, there are actual and statutory possibilities. And then in the event of willful infringement, meaning that somebody perhaps has asked permission, been denied, and goes ahead and uses the work anyway, or knowingly violates the copyright, punitive damages may be available in that case. In rare cases, we'll talk about one, destruction of the infringing material may be appropriate. And in incredibly rare cases, generally having to do with piracy, there are criminal potential remedies as well. All right, so when accused of infringement, one of the most common counter arguments is fair use. It's really important to remember that fair use is in fact a defense, so it will only come up once you've been sued. Even in situations where fair use is a legitimate defense, it can't keep you from getting sued. So it just provides you with that strong argument in court. this is a crucial thing to keep in mind, because I'll often get the question from somebody, well, can I use it? It's fair use. It's like, well, yes, I can make a great argument for you that this is fair use, but you're only going to be able to use that argument if you end up getting sued. It's not going to put you in a position where you can prevent that lawsuit from happening in the first place. In determining whether the use made of a work in any particular case is a fair use, the court will consider 4 factors. The purpose and character of the use, or also referred to as the transformative factor, and this is really crucial because this is the factor that courts are relying on most often these days for fair use. The nature of the copyrighted work. Actually, let me back up for 1 second and just give a little more explanation for transformative work, because we are going to talk about a couple of cases. But in some recent case law, the Supreme Court has emphasized that the purpose or character of the use of copyright is the primary factor, or of course, lack thereof. The question really boils down to whether a particular use of copyrighted material has transformed the new work, or the original work has been transformed to such an extent that essentially there's a new work that's worthy of copyright protection. So this is a pretty difficult standard to nail down. There's no way of any lawyer or anybody saying this is absolutely fair use or not fair use based on this transformative factor. But it is an argument that can be made, and we do have enough case law and enough examples of things that are truly transformative that we have a little bit of guidance available on that matter. But things like taking a whole lot of different elements and collaging them together, or merging them together in a way that is not anticipated by the original underlying work, would be kind of the idea behind transforming a work. And now, of course, you've also got the artists who are engaging in appropriation work, which is a whole other interesting conceptual category to be talking about, as to whether simply taking a work in its entirety and relocating it or putting it in a different context is going to be enough to create a transformative work. Okay. 2, the nature of copyrighted work. Because the dissemination of facts or information benefits the public, there's generally more leeway to copy from factual works, such as biographies, than you would for fictional works. Obviously, there are some limits to that as well, but important to understand those differences. Okay, 3, the amount and substantiality of the portion used in relation to the copyrighted work as a whole, meaning it does matter how much you take and the importance of what you're taking from the work. So it could be either a very large portion, in which case, obviously, you've taken a great amount of the work. But if you've taken the heart and soul of the work, even if it's a smaller portion, percentage-wise, it could still amount to an infringement that's not justifiable by fair use. This is a really important factor to understand as well, because I often hear from people, if I change it 10% or 20%, doesn't that get me out of infringement territory? And the answer, again, is maybe, but probably not. There just isn't a strict formula that can be applied. Okay, the 4th factor is the effect of the use upon the potential market or value of the copyrighted work. And this is the aspect that is brought up most frequently. Well, I'm using it for educational purposes. Yes, that is one basis on which that you could be able to claim fair use, but just the fact that you're using it for a nonprofit purpose or for an educational purpose is just one of the factors that's considered. And in this case, it could be that even if you haven't profited personally, there's an effect on the potential market for that work that you've undermined by that use. And so taking a look at that is, like I say, one of the 4 factors. There is actually a 5th factor that I like to refer to. It's not something that's been specifically indicated by the courts, but I call it the jerk factor. And this factor is something that you're not going to find specifically spelled out, but time after time you can read between the lines to see that the court will also consider this jerk factor when looking at matters. If you're disrespectful in the process, the court, or even to your adversary, it's likely that the outcome is going to be, that will be reflected in the outcome of your case. The takeaway here really is that there is a fair amount of subjectivity that the court can employ in coming to a fair use decision. In fact, the court can even decide if very little infringing material is at issue, as I mentioned before, and very little in terms of demonstrable damages. The court may determine that that there is or is not. If it's a very small use and a very small amount of damage, there is the possibility that the court would determine that there's really no basis for complaint or liability. And this is where you'll hear reference to the term de minimis. So if something is determined to be a de minimis infringement, it's not really worthy of punishment. Okay, so we're going to take a look at one of the most publicized and interesting recent cases. This was a case between Patrick Carreau, a photographer, and Richard Prince, an artist. You can see here there are two images that didn't translate so well to the larger slide, but you get the idea. And many of you may be familiar with this case already. On the left is the original photograph that was taken by Patrick Carreau. On the right is the work that was made by Richard Prince. There's way more to be said about this case than we could possibly cover today, but let me just be very brief. Prince made 30 paintings based on Carreau's photos. The series was called the Canal Zone series, and several of them sold for anywhere between $6 and $10 million through Gagosian Gallery. The photographer sued Prince and Gagosian for infringement. Prince claimed fair use, arguing that he had transformed the work, that his additions had created a completely different work that was legitimate and deserved its own protection. The district court, meaning the lower court, found that Prince's work infringed and did not qualify for fair use. The court held that in order to be fair use or transformative, Prince's work had to be a comment on Carreau's work or on aspects of popular culture closely associated with the work. This reasoning is based on an earlier seminal case from the early 1990s against another artist who likes to push the boundaries. You may have heard of Jeff Koons. The court in this case, though, was looking for an articulated statement of intention behind the appropriation of Carreau's work. And this is kind of an important issue because it goes to the underlying issue of conceptual work and what artists are required to articulate or not as they establish their practice, and then also worry about issues like this. The district court was not convinced that Prince articulated an intention, and so at that level they ruled against him. And in a really surprising verdict, they also ordered that the infringing work be destroyed. So you can imagine how the collectors felt about that after having paid millions of dollars. None of the work, except for maybe one that Prince perhaps destroyed publicly, none of them ended up being destroyed because the case was unsurprisingly appealed. Prince won on appeal with regard to 25 of the 30 works. And the appellate court that found that, in fact, Prince's work was transformative and created a fundamentally different aesthetic that was entitled to copyright protection. So for those, of course, who champion appropriation art, the appellate court outcome was far preferable than the district court. Nevertheless, critics raised a number of interesting questions, which I think are important when considering these kinds of cases, which is whether courts should be in the business of assessing the aesthetic merits of artwork in the first place. So this is obviously a huge debate and one that we do not have time to get into today, but just wanted to raise that as an interesting issue to be aware of. So the question of the remaining 5 paintings, as I said, 25 of the 30 were determined to be transformative. 5 were still in question. There was a settlement in the end, and before the ink was even dry on the settlement, Gagosian had already planned another show of the Canal Zone works. And as any good appropriation artist representative does, Gagosian took it a step further and created derivative works in the form of merchandise like Canal Zone posters and catalogs and t-shirts, which it sells in its online gift shop. I did look to see about the t-shirts. They are sold out, but I believe there are some posters available. So from a collector's standpoint, the outcome is certainly a relief, right? Not only do the collectors who bought the work initially not have to destroy their pieces, but all the publicity around the controversy has likely created more value for those works and increased everything on sort of a fast track. which of course begs the question as to whether legal controversies around copyright issues, albeit risky, are ultimately the new best marketing techniques for high-priced artists. All right, moving on quickly. Again, moral rights, another important aspect of intellectual property. Long recognized in Europe, which is how I was able to justify this lovely picture of Paris. But the US has only recently recognized moral rights with the 1990 implementation of the Visual Artists' Rights Act. This was passed so that the United States, and one of the reasons, but one of the main reasons is so that the United States could participate in the International Berne Convention, which is an international copyright treaty that allows the recognition of copyrights amongst the signatories, allowing for recognition of your copyrights in the US in other countries as well. There is no international copyright per se, but anyone who's signed on to the Berne Convention recognizes each other's copyright laws. So while much of the world recognizes 4 distinct aspects of moral rights, number 1 being authorship, being the right of attribution or credit for your work. Number 2, the right of integrity. In the US, this right prevents the destruction or mutilation of works of recognized stature, which we'll talk about in a minute. 3, the right of disclosure, or the right to determine when a work of art is finished and suitable for public presentation. And then 4th, in some limited cases, there's the right to withdraw or modify work. In this case, an artist would need to indemnify the owner, in other words, pay the costs of modifying or withdrawing that work. But in the US, let's see if I can get my slide to change, we only recognize authorship and integrity, and the other 2 are really something that are purely recognized in other countries, mainly in Europe. Authorship and integrity are protected in the US, and it's protected under the Visual Artists' Rights Act, as I mentioned. Unlike copyright, which attaches to the artwork, the Visual Artists' Rights Act moral rights attach to the artist. So personal and unassignable, but they may be waived, and they only last for the life of the artist. In other countries, those moral rights may or may not be waived and may last beyond the life of the artist. So it's really important to understand the context within which moral rights are being asserted. But as far as the US goes, they can be waived, which they often are in commission agreements, and they only last for the rights of the artist. If VARA rights are violated, the artist has the right to take his or her name off the work so that it's no longer associated with the artist or included in that artist's body of work. Other legal remedies available under federal law for violation of moral rights are the same as the civil remedies available for copyright infringement, namely money damages or injunction. Some states have additional rights. So again, this is referring back to the fact that there are several different levels of laws in the US. Since VARA is a federal law, it takes precedence over the state laws, but nevertheless, there are several states that I've listed here that offer some separate and in some cases additional protections for artists. In some cases, they're maybe not necessarily all exactly in line with the federal law, so there can be some conflicts that one needs to take into account. But again, important to understand that the federal law takes precedence in any case. I know I am going over here on time, but I just want to run through a couple cases, and I think we're just about to wrap it up here. So luckily, there aren't that many cases to talk about, but I've picked 2 that address some of the moral rights issues brought under the Visual Artists' Rights Act so that you can get an idea of how they've applied in real life. So on the left is Katie Nolan's Log Cabin. And in this case, again, very briefly, just skimming the top surface of this case, the collector who owned the piece lent it to a museum where it was displayed outdoors. As you can imagine, you can see it's made out of wood. Eventually, some of the logs in the piece rotted away, and conservators replaced the logs with logs from the same manufacturer who produced the logs for the original manifestation of the work. The work was subsequently sold for $1.4 million. And at that point, the artist heard about the restoration work that was done, and she was not happy at all about this and disclaimed the authorship of the work under VARA, rendering it obviously much less valuable than the purchase price of $1.4 million. Nolan then sued for copyright infringement, claiming that the reconstructed log cabin was tantamount to an unauthorized reproduction of the work. And this case is an interesting case because it really does raise important questions about what does authorship mean? What are collectors allowed to do in terms of conservation of the work? And of course, the most basic question, what is art? Which of course, once again, we are not going to answer today. Another important case, the one on the right here, the 5 Points case, actually just concluded a few days ago when the attorneys representing the artists in the 5 Points case were awarded their attorney's fees. These were as I say, the attorneys for the artists. They were awarded $2 million, which brought the total verdict up to $8.75 million against the developer who whitewashed the artist's work that was painted on this complex of buildings in New York City. This was kind of a surprising case because traditionally in the United States, we see real property rights as being the most important thing. And so I was convinced when this case first was making its way through the courts that the court was going to find some way to favor the developer. But in fact, that is not what happened. In this case, the court took great pains to consider the complex issues of what makes artworks works of recognized stature, which, as I mentioned before, is one of the qualifying factors for being protected under VARA. But the key factor here really does go back to that fifth factor I mentioned of the jerk factor. It's not just important in fair use cases, but it turns out it's also important in VARA cases. The developer in this case failed to give proper notice under the terms of the Visual Artists' Rights Act before he whitewashed the artwork. So those moral rights that are protected under VARA are protected, but there are ways for property owners or the owners of the artwork to get around it by giving notice and allowing the artist notice and an opportunity to either take the work back or make some other arrangements. So in this case, the developer did not do that. And not only did he not do this, but throughout the case, he was rude and disrespectful to the artists and to the court. You know you're in trouble when the court takes a lot of real estate up in their opinion, writing about how rude you are to the court. So in this case, the court did spend a lot of time pointing out how rude he had been in the opinion. So again, in the end, the result was that the artist won. It's been touted as a case that is, I think, more important actually to artists than it actually is in the end. In the end, I think the case really goes to underline the fact that developers and property owners are, in fact, required to follow the law. They have to follow the word of the law in the Visual Artists' Rights Act, as well as the copyright law in general. What it also shows is that there is real money at stake here, not just on the side of property owners, but on the side of artists as well. Speaking of real money, we will get to our last topic, which is resale royalties, which will be very quick because there aren't any in the United States. This is an area that really no one has figured out how to effectively regulate through legislation. It's been tried a couple of times. There's a lot of conversation at the federal level that has not been able to be implemented. But in California, I think this is my next one here. Yes, California is the only state which tried to actually implement the resale royalties statute. But in 2018, there was a case in which Chuck Close, Laddie John Dill, and the San Francis estate sued Sotheby's and Christie's, saying that that they weren't complying with the California law, and the court declared that the Resale Royalties Act in California was preempted by copyright law, and so for all intents and purposes did away with the law. It was declared to be unconstitutional. As I mentioned, there have been discussions at the national level about national legislation, but it's just never come together for a variety of reasons. Though I will mention that since COVID, there's been a much stronger conversation that started, a lot of rumblings in the artist community about re-examining the value of artists' work and the need to revisit this issue of resale royalties. I think that what we're going to see is a shift where issues around resale royalties and ongoing economic interests in creative works will be taken care of more through a contractual process. I know Susan Schwartz is on the call today, and she's somebody who's been working really hard on this issue. So maybe we'll see some movement as the market mechanisms of the art world shift and change during the recovery that we will hopefully begin to see this coming year. And with that, I'm going to turn it back over to you, Katie, for questions.
Thanks, Sarah. We actually have quite a few questions that have come in during the chat that are all really interesting.
I'm having a very hard time hearing you.
I guess it would help if I moved my microphone down. Apologies. We have a lot of questions today, so I'm going to jump right in. The first question was, will we have access to a recording of this webinar? I'd like to know if I can go back and watch it. Yes, I am putting in our YouTube link right now, which I will also send out to everyone in an email. Currently, the first two workshops in this session have both been posted to that YouTube page, and I'm having a little issue with the third one, but I'll get it up as soon as I can. Something's happening where it won't upload, but I'll get it going. And then this one will also be there as well, coming soon. So there's the YouTube link to the YouTube channel. Then the next question is, would you recommend to copyright fine art paintings, or is that a different area of law?
Fine art painting, no, that's exactly what should be copyrighted. So absolutely, paintings should be copyrighted. Luckily, like I mentioned earlier in the presentation, the cost for filing the copyright registrations is not terribly high. So it's something that most artists can manage, and most artists can manage several at a time. My recommendation to artists generally is to look at your work on a quarterly basis. There are some very good reasons to register the work within 3 months of its creation or its availability to the public. And again, because we were just scratching the surface today, unfortunately, I didn't have enough time to go into all of the details. But if, as an artist, you put into place a practice whereby you are assessing what you've created every quarter and filing registrations on those things that you want to make sure are protected under the copyright law, that's the best cycle to get into. So yes, this applies to paintings, drawings, performances, musical compositions. I mean, really any form of creative work that has been fixed in a tangible medium.
Awesome. So I'm going to try to go through all the questions quickly, and then I'll come back at the end and see if there's anything else we need to address on any specific question. So our next question is, do you have to have two separate copyrights as a songwriter and a music artist, i.e. composition and the recording? And do you have to have separate copyrights if you want to use lyrics on merchandise?
Yeah, that's a really excellent question. Yes, you generally are going to have two separate copyright registrations for lyrics versus musical composition. And oftentimes, as musicians know, and those of us who listen to music know, there are different people involved in the creation of musical works. And so you'll have one person who's doing the lyrics and one person who's doing the composition, and then that's fine. Those can be the separate authors for each of those components. You may also have a third registration for the recording of that music. So with music, you've got a lot of different components, and it brings in questions of joint ownership, which can get a little bit complicated. And joint ownership can be both in music as well as any other collaborative work of fine art. And what's important to understand about joint ownership of copyright, so that would mean that you have not just one author listed, but multiple authors listed on a copyright registration claiming interest in that ownership. The thing to remember there is that everybody has an undivided interest in the whole. So anybody who is a joint author can use that work in any way that they want. Their only obligation is to account to the other authors for profits that are made. So that can obviously lead to some challenging situations. And so whenever there are joint holders of copyrights or multiple parties involved in creating works, it's my recommendation that there's also a contract in place, some form of agreement where everyone understands and recognizes the obligations and responsibilities and how everybody wants to treat that work that they've all collaborated on. That can often cut down on issues that might arise later when there could be disagreements as to how that work is used. So I realize that's, and just one other point, if you look on the copyright website, there are different kinds of forms that are used for different types of work. So when you're registering the work, you're going to have to look at the type of form that's listed there in order to determine which one is the appropriate form to use. So TX would be for textual works, VA is for visual arts, and of course there are different forms for musical recordings as well. Oh, and there was one last part of that question about lyrics on merchandise. So in general, and again, didn't get to go through the full copyright presentation, things like t-shirt logos t-shirt sayings that are put on t-shirts, game instructions, recipes. There are a lot of things that are not protectable, not because they're ideas, but because they are very limited in terms of the way that they can be expressed. So my answer is going to be, it depends. It may be that your lyrics are enough to be copyrighted on their own. It doesn't matter whether they're on a t-shirt or on a piece of paper or on a lunchbox or mug. They are protectable. If it's something that is a very short phrase or title or something that would unnecessarily or inappropriately lock up certain words by being protected, then you probably won't be able to get protection for that. But this is also, when we see merchandising happening, this is also where we see the crossover between copyright and trademark issues.
Awesome. Big question.
Yeah.
Okay. So the next question is very specific. Is the City of Phoenix bird protected by copyright? I believe your explanations have answered this, but because it is so heavily reproduced throughout the valley, I'm curious. For example, if someone uses the exact outline shape of the bird, but filled in the outline with letters only, is that a violation? So I'm going to add something to this question. In the chat box, I put a link to the official City of Phoenix web site about that logo. That has direct contact information to our City of Phoenix communications office that can answer questions like that specifically. And usually they're really responsive and can work with you on those types of issues. But Sarah, do you have anything to add to that?
Well, I don't know what the status of the Phoenix bird is, but there are some issues around government ownership of works, and oftentimes works that are created by the government are not eligible for copyright protection. But there may be some trademark protection, there may be some other intellectual property protection available. Certainly, if somebody is inappropriately using a city seal or some other representation of a municipal entity, that can be stopped because you don't want people to think that that there's some official activity that's actually not an official activity. So it depends also on the context in which that symbol is used. Is it used, within a painting in a creative sense, or is it being placed on someone's letterhead to indicate that they're somehow connected to the city if they're not?
To be sure, I would just recommend that you contact this communications office and check with them before usage. Okay, I'm going to move on to the next question because we got 8 minutes. Have you ever heard of the issue of a trade dress conflict between artists working in the same style and medium, and thus creating confusion regarding authorship, though the content may be different?
That is also a very interesting question. And at this point in the United States, for the most part, you cannot protect style of work, which is problematic for a lot of artists. But that's where the law is right now. That's not the case in some other countries. In fact, I'm aware that there's a case in Italy that just came down recently where style of work is protectable. So that's definitely a gray area. And I'm not sure, I don't have any cases off the top of my head that I can cite to, but certainly when you're bringing a claim for copyright infringement, and let's set the trade dress aside, but if you're bringing a claim for copyright infringement, the standard that the court applies for copyright infringement is substantial similarity. So is work A substantially similar to work B? And so again, you get into a bit of a gray area. It's sort of a mushy standard that's going to be based on what the jury's interpretation of the two works is. So when you get to that point where the two works are substantially similar, then you could potentially have a copyright infringement matter. But in terms of, in general, being able to protect a style of working, that's something that's a lot more complicated.
Great. I think this is when we've kind of we've got it asked in two different ways. Can you copyright a collection of work under one copyright? And then someone else has asked, can one copyright cover a painting series that's clearly linked? I think those are two very similar questions.
Yeah, and the Copyright Office actually just changed the rules on this. So you still can register groups of work on one application, but it's a little bit more limited. For photographers, this becomes a much greater issue. And so there's a separate group registration process for photography, because you've got contact sheets with hundreds of photographs, and you may want to protect everything as a blanket, not knowing exactly which one is going to end up being printed and used and available, or garnering attention. So the answer is yes, but you have to be careful about how that happens. And it can't just be any groups of work put together. There's got to be some coherence and consistency in terms of why that group of works would be placed together. You might be able to say, Q1 of 2002, these were the works I did, and I'm going to copyright them. But generally speaking, if it's a series of works that has some connection with one another, then you can do the group registrations. That said, I always recommend that people pay close attention to what they're putting on those group registrations, because let's say you've got 10 pieces and one piece has garnered a lot of attention and the other 9 not so much. You might want to still consider separating out that one piece that's gotten the attention and protect that separately. The reason being that if you've got any sort of claim that comes up and you're using the group registration as the basis for that, it's possible that you're calling into question the protection for all of those works when just addressing the issues around one. So it's not a terrible process, or it's not a terrible habit to have, to put in place a process by which you're protecting works in groups. That's certainly a more efficient and less expensive way to do it. Just be careful about how you allocate those groups and format those groups. For the most part, the Copyright Office doesn't look as closely at what you're registering as the Trademark Office does. The Trademark Office does quite a lot of background check and looking into other things and cross-checking. And the reason being, of course, that if the purpose is consumer protection, it's a much different underlying reason for granting that trademark protection. Whereas with copyright, they look to make sure that it's the appropriate type of thing to be registered, but there's not going to be a lot of research and analysis put into what you've submitted, or less so.
Great. We have so many questions that are really good. I want to make sure we get to all of them.
Maybe this should be the topic for one of the sessions we do in the new year.
Yeah, I wrote that down. It sounds like we might need another workshop on copyright to go into more detail. Yeah. So we've got like 3 more minutes. I'm going to go through as many as we can. And then we might need to revisit this in January. If you guys think that's a good idea, please type it in the chat box. The next question is, should you copyright your music before you release it or even share it on a social media platform?
That's easy, yes.
Okay. Yes. Next question, kind of statement. I heard there was a formula of 3 steps of removal, as in Shepard Fairey's Obama Hope poster. So for example, color changes, background changes, reduction to graphic shapes. And then I think the question is, so I take it there is no such rule of like
There is
3
no
steps of
such rule.
separation.
Yeah, there's no such rule. The only standard is the substantial similarity standard. And then, of course, those factors that I went through for fair use. So, those are aspects that one may point to in making a case that there's been a transformation, or that it's not substantially similar. But the only standard that applies in court is there substantial similarity? Has copying occurred? Is it substantially similar?
Okay. I think we've got time for one more question, and I got 2 that are very similar. So maybe we'll get started on it, and then maybe I think we will revisit copyright later on if possible. Could you talk more about the requirement to put the copyright information on the artwork? And then this is sort of a follow-up. If you simply put the copyright symbol with your name on your website without registering the work, is it legal and protected?
Okay. I'm glad you brought that up. That is something that I glossed over. I really addressed the notice issue very briefly, so my apologies. The old law before 1990 required that you have the copyright notice on your work, otherwise it could potentially fall into public domain. Now, the rule is that you don't need to have the notice on your work in order to secure your copyright. So there's no current notice requirement. There's no requirement to have that notice on your work. However, it's a really good idea to have it there because it notifies people that you're aware that you have copyrights in the work, and it also could potentially support claims if you have an infringement claim for willful infringement, right? If that notice is on the work, then somebody can't really claim that they didn't know that it was copyrighted, or that you were claiming protection in it. So notices are not required, but they are a very good idea, and I recommend that everybody use them as much as possible. What was the last part of that question?
If you simply put the copyright symbol with your name on your website without
Right.
registering the work, is it protected?
So as I said before, we have sort of a weird system in the US where we require this registration. Other countries don't require registration in order to assert copyrights, but here you have to have that registration in your hand to be able to go into court. So when you create your work, whether it's on your website or anywhere else, you have copyright in it as soon as you've fixed it in a tangible medium. So you technically have the copyright. You just can't do anything with that copyright until you've registered it through the Library of Congress. So it's a good idea to put your notice on your website. You have copyright in the work, but if you haven't registered it, you can't pursue any infringement claims. And it's possible that if you wait too long, you'll have a gap when an infringement occurs during which you will not be able to recover statutory damages or attorney's fees. So the sooner the better with the registrations.
Cool. Okay, we have hit the limit on our time, but I do have some additional questions that hopefully maybe we can tie back in later. I've got questions about marketing and private businesses and photography. So hopefully we'll be able to come back to all that later, but thank you everyone for your questions. Mitch, do you want to wrap us up?
Well, I just wanted to say thank you again to Sarah and all of the participants. I see that we've had some with us all 4 sessions, and we look forward to presenting more workshops in the new year. And if we don't speak to everyone, have a safe and happy holiday season.